So welcome everybody. This morning in our enterprise series, we're going to be covering expanding your business internationally. As usual, quite a few familiar faces or names on the delegate list, quite a sort of a regular following of you that attend these webinars. So quite a few of you are probably familiar with who we are, but for those of you who aren't, Moore Kingston Smith is a top 15 audit, tax and advisory firm. We work with sort of entrepreneurial clients across all different sectors, as well as not-for-profit and private client as well. And we're also part of More Global, which is an international network with presence in over 100 countries. So very well placed to help you on your international expansion journey. So today's session really focuses on what businesses should be considering when they're expanding internationally, and whatever the reason for expanding overseas, successfully becoming an international operation does require a lot of careful planning and consideration. And obviously businesses will have different priorities, but they should be prepared to deal with local legal and regulatory requirements, as well as other factors such as local tax and immigration requirements, and also dealing with different currencies. So I'm delighted this morning to welcome our panel of experts who are going to be telling us all we need to know to enable our business to expand internationally. So Darren Jordan is one of our partners. He's an experienced advisor to growing international businesses and supports all aspects of assurance and accounting. And he works with businesses across all different sectors, but with a particular focus on construction, real estate and technology. And Darren uses his extensive global network to support clients trading overseas and expanding into new markets. Ruth Brennan is a corporate tax partner, and she leads the delivery of corporate tax compliance and advisory services to a broad range of clients, including international groups. And as well as advising on aspects of domestic and cross-border transactions, she also leads the firm's transfer pricing services. John Williams is one of our directors in the employment tax team, and he provides compliance and advisory services. And John's expertise spans a broad range of sectors, including finance, technology, and media and manufacturing. And his experiences sort of really allow him to recognise important areas of risk specific to his clients and offer them solutions in line with their individual requirements. So a little bit of housekeeping. This is being recorded, so please do share with your peers or anyone who couldn't make it this morning. And please do ask questions. This webinar is for you. It's for you to get as much out of it as you want to get. And that often happens when you're posing questions to our panelists, and they'll try and weave those questions in the relevant places as we go along. Any questions that don't get answered throughout the course of the webinar, we will seek to pick those up with you individually afterwards. And our next session, just to let you know, will be on the 13th of June, and we're going to be focusing on embedding learning and development within your organisation. So I'm going to do a bit of light sharing, and the panelists are going to do most of the speaking. So we're going to kick off with Darren. So Darren, what really should businesses be prioritising first when they're considering setting up overseas?
Thanks, Esther. So when I'm talking to businesses, I start off by breaking it down at a high level to them being a provider of goods and or services. They usually are hiring people, and there's usually a transfer of money. So as you said in your opening lines, management need to have a strategy and a plan to ensure they understand how their business here in the UK will translate to another country. Often businesses do look the same when you're seeing them from the outside from different countries, but usually culture, laws, and market practices mean that to get to the same external view, internally, it often has to operate very differently. So it's important that businesses and management have a strategic plan in place to understand the critical points before entering that other market and how they're going to deal with it, or alternatively have a plan B. Mostly businesses, when they're going internationally, are generally for two reasons. One, it's to either hire people, or it's to increase their market for their goods or services. Like ourselves, many businesses struggle to find talent, and so they often find that there are good, qualified, capable people in other countries that can help address talent shortages, or they might find that they're just cheaper. But mostly, and most of what I'll cover here is businesses who are looking to expand their markets. So mostly, most businesses, when they're starting to increase their markets internationally, they start trading with a country. So that's selling from the UK to customers in another country, and then depending on how that's progressing, they will often then decide that they want to set up in that country. And one point that isn't often fully appreciated by businesses here in the UK is that around the world, brand UK actually is very well regarded, and businesses, UK businesses, should be confident and optimistic about their opportunities internationally. I'm not convinced enough SMEs realise what opportunities there are around the world. So when looking at setting up overseas, each business, as you've already said, Esther, will have different priorities. So, for example, a construction company will have different challenges to marketing services companies, and those internal differ to companies which are an exporter of products. But broadly, you can break all areas down into a few categories. So firstly, market demand. Have management got enough comfort and idea around whether they've got sufficient demand for their products or services, and is there sufficient interest for a potential ongoing growth? Secondly, customer preferences. Do management understand the preferences, needs, and expectations of overseas customers, and how offerings need to be tailored for regulatory or cultural market practices? Three, talent, and I know John will probably cover this in a lot of detail. So for different service providers hiring in different countries, you need to think about what skills and connections and know-how they can be provided with, and whilst there's a few tax pieces in there, I don't think businesses here in the UK really consider how they can utilize talent elsewhere around the world to help them grow their whole business, including growing their business here in the UK. Four, financial viability. Has management looked at the risks associated with setting up overseas? What are the investment costs? What are the ongoing operational costs? And what are the potential returns on investment? As you know, there are a variety of ways in which management can avoid setup costs by outsourcing a lot of businesses, a lot of setup services. I mean, we here in the UK obviously help a number of international groups control their UK businesses remotely through our services, and there's a whole variety of ways in which UK businesses can set up more cost effectively overseas. A common bane, opening a bank account. If you are operating remotely a foreign subsidiary, opening a bank account is a pain, and it's the same the world over. But there are some technological alternatives. So there are e-payment services which are very good and very credible, that have the same functionality as bank accounts, and I believe there are also one or two BACS type technical services that can also be used now to help with the utility of a bank account if opening one is proving problematic. Foreign currency is another area where SMEs often are unsure what to do. Most are reluctant to use hedging products, and so in most SMEs, when they're expanding internationally, look at what their exposure is, and try and work out a natural hedge by working out how they can balance off income and costs in foreign jurisdictions as far as possible. But I would encourage SMEs to look at hedging options if once they're a bit more mature. Then next is the legal and regulatory and cultural requirements. It takes time to get to know markets, particularly if you're going to set up there. And often businesses probably create too much infrastructure too soon because they haven't done enough market research on where they need to focus their time and efforts and prioritize efforts by deciding which country to go to first. And ultimately, the easiest way for businesses, they can obviously look at the commercial side of it, but then using advisors, our equivalents in other jurisdictions, talking to other businesses about what they have done, should make all of these awkward judgment calls a lot more manageable. I mean, broadly, most countries have similar rules to the UK. They're just perhaps operated differently. So getting local advice, I think, is really important there. Then next, in terms of logistics and distribution, how can management ensure that products or services to overseas customers are delivered as efficiently as possible? And, you know, with technology and the use of the internet and video calls, you know, the costs of doing business overseas now is a lot less than it used to be. But it is still potentially complex, and you do need to make sure that you're well advised. And then lastly, it's just practical considerations. You know, setting up in Europe is different to perhaps setting up in Japan. So how a UK business might manage that with a secondment or an exchange or hiring people locally will differ. And equally, you know, if a business is selling goods, then they're not going to want to put in a whole infrastructure for supporting their goods, and they will look at their supply chain. So there are a lot of factors to consider, and you know, the nuances of each business varies greatly. So I think I'll probably leave it there for now, and we can get into more detail if necessary later.
Thanks, Darren. I mean, I've often found with my marketing services clients that are looking to set up overseas, it has worked particularly well, whether there's been someone from the UK that's been willing to relocate over there, because in terms of transporting the culture of the business, you're sort of trying to marry the culture of the existing business with the culture of the territory that you're expanding to, and obviously sending someone over helps sort of join the dots. So yeah,
absolutely. And I think it also helps with in putting that culture on, but it also helps to give that external view of how well regarded UK businesses, particularly in marketing services, are viewed internationally. And I just don't think SME businesses here in the UK really understand how well the UK is regarded.
Yeah, no, absolutely is. So, John, I mean, it's sort of a typical scenario in a business life cycle would be a UK business looking to establish initially a relatively small footprint overseas with maybe 1 or 2 employees. So what are the employment and all sort of the payroll issues that we need to think about?
Yeah. Okay. Thanks, Esther. I mean, as you and Darren were describing there, the chances are that the UK company would second a UK member of staff to overseas at this early stage to test the market in the overseas location. Now, before I get on to any tax and payroll implications, first and foremost is that does that UK employee, probably UK citizen, have a right to work in the overseas country? And that will vary from country to country, and there's a need to seek immigration advice. Chances are you need to have a visa in place in pretty much every country. then moving on to the tax and payroll side of things, because this individual from the UK is likely to only be there for a short period of time, maybe 6 months, maybe up to a year, they're going to still be liable to UK tax on their salary whilst they're working out overseas. But turning to the overseas position, so the overseas tax considerations for that employee, whilst it's unlikely that there's going to be any permanent establishment or presence in the overseas location for the UK business at this early stage, depending on the country and the duration, there may be a tax and a social security charge on that employee's earnings whilst they're working out there. But fortunately, the UK has double tax treaties with a lot of countries, which means that for very short periods of time, so less than 6 months, there's ultimately no income tax charge in that overseas location on that employee's earnings, which is a nice and easy outcome for these sort of initial stage posted workers. But if we've got an employee who's been posted for more than 6 months, or there's no double tax treaty with the other country, then that employee probably will suffer a tax charge in the overseas country on their salary, as well as suffering a tax charge in the UK. So there's a need for the UK company to establish who's responsible for paying over that overseas income tax. Is it the employee, or does the employer need to run a payroll for that purpose? And any double tax charges that need to be considered a consideration of claiming a credit in the UK to eliminate that tax charge for the employee. Social security rules completely separate to tax rules, but there might be better news here in that if the UK has a reciprocal social security agreement with the other country in which they're being posted to, typically they can remain contributing into UK social security, so national insurance contributions for periods of typically up to 2 years, which is the case with European Union countries. But of course, if there's no reciprocal agreement, then there will be an employee and an employer social security charge in that other location, which needs to be dealt with typically by the employer. Now, so that's your posted, seconded worker situation. It might be the case that to help out that seconded worker, the UK business hires someone locally in the overseas location. Now, where they're hired locally, that individual would be subject to local taxes and local social security. And it's highly likely the UK company would have to run a payroll in that overseas location, issue employment contracts under local laws, deal with mandatory pension and benefit requirements. So quite an onerous obligation on the UK company. And I often see clients, particularly in recent years, looking to use what's known as an employer of record solution, which is effectively a third-party organisation, so not connected with the UK company at all, that will legally hire this local employee. They'll pay them, they'll deal with all the payroll, they'll deal with all the employment law and issuing of contracts and any other HR obligations, all sort of outsourced on behalf of the UK company, obviously in return for a fee. But I think my final point here is if businesses are using these employer of record businesses for this purpose, that due diligence must be performed on these organisations by the UK company to make sure they are doing what they're saying they're doing, particularly in relation to paying over the correct amount of taxes in that overseas location.
Thanks, John. I mean, Ruth, obviously there are lots of considerations as well in terms of how one goes about structuring the overseas entity and lots of corporate tax considerations. What do we need to think about here from a practical perspective?
Yes, thanks, Esther. So when starting operations overseas, thoughts might naturally first turn to simply incorporating a subsidiary in that overseas jurisdiction. So a foreign sub would operate autonomously from its parent company. It would be accountable for its own assets and liabilities, and it's considered to be a separate legal entity for tax and regulatory oversight. And there may in fact be operational reasons why an overseas sub is preferable, but of course it does represent quite a significant degree of commitment to the overseas business. And a key tax aspect that UK businesses incorporating entities overseas need to be aware of is that the overseas company may also be subject to UK tax on all its profits, as well as overseas tax. And that would be the case if the company were also considered to be UK tax resident. And an overseas incorporated company could be UK tax resident if it's centrally managed and controlled from the UK. And there's quite a lot of guidance and case law on this. But put simply, even if the overseas entity has locally resident directors, if the reality of the situation is that it's really the UK resident board of the UK parent company, or otherwise perhaps as UK resident individuals that are effectively the controlling brain of the group and determine the strategy and direction of the overseas entity, then as far as HMRC is concerned, the company will be UK tax resident and therefore obliged to register and file tax returns in the UK accordingly, just as though it was a UK incorporated company. So it can be the case, therefore, that overseas subs can be dual tax resident. So ensuring that ultimately tax is only paid once on profits is going to be key. And the first port of call to resolve this would be to look at the relevant tax treaty between the UK and that relevant jurisdiction to see whether there's a residence tiebreaker provision that could be utilised. And a common tiebreaker in tax treaties is that sole residence can usually be awarded to the jurisdiction where there is day-to-day effective management. So that's kind of operational day-to-day management. So that feasibly could result in sole residence being awarded to the foreign subsidiary. And then if that still ends up with both UK and foreign tax being due, then there are double tax relief mechanisms that would need to be looked at to hopefully end up with a position whereby the foreign tax suffered can effectively be deducted from the UK tax payable in the UK tax return. So the end game should be to make sure that tax is only paid once on profits. And usually the applicable tax rate would be whichever is the higher of the UK and the overseas tax rate. So an alternative to going straight to incorporating a subsidiary could be, and it's perfectly possible for the UK company to simply start a branch of the UK company overseas. So basically start doing business there itself, perhaps by, as John mentioned, employing some staff locally, sending some staff over to generate and deliver business, perhaps even renting some sort of office in its own name. That could be a way of testing the water overseas without the full commitment of having an actual incorporated subsidiary. Now, the tax status of the branch, it would generally depend on the nature of the activities being undertaken. There would be a requirement for the UK company to register with the Overseas Tax Authority if it was generating sufficient value there, such that there was a taxable presence. And the term for that taxable presence is permanent establishment, commonly known as PE. And that's an internationally recognised concept. And a company would have a PE in a jurisdiction if it had a fixed place of business there through which it was doing company business, or if it doesn't have a fixed place of business, alternatively, if it had employees or agents operating over there, and those people were negotiating habitually and concluding contracts with customers. So if the analysis were that the UK company had a PE, then it would be the UK company itself that would have to register for tax in the overseas country and then calculate how much of the UK company's profits are actually attributable to the PE and then file the appropriate tax return and pay any tax due on that profit. The calculation of those attributable profits could be straightforward if it's easy to effectively split the UK P&L between its component parts, i.e. between the UK element of the business and the overseas element. But sometimes it can be fiddly and require overlaying other techniques and methodologies to get to the right result. So with a branch that has a taxable presence, PE presence overseas, again, we could have a situation whereby both UK tax and foreign tax are payable on the same profits. and making sure that double tax relief is claimed appropriately in the UK tax return will also be key. So really, in terms of the subsidiary versus branch decision-making process, there's a few things to consider when planning. Maybe if testing the water and losses are envisaged in the earlier years, that might make you lean more towards a branch structure, perhaps, as those losses would also be utilisable in the UK. And it's relatively easy to move from a branch to a subsidiary structure by incorporating a branch, but perhaps not so easy the other way around. But yeah, those pros and cons, they're something we regularly look at for clients in collaboration with our more network colleagues overseas. Just as a final aside on tax structuring, I've focused on corporate tax structuring, of course. I'm very much not a VAT expert, as it's such a specialist area, but it's important to note also that VAT is another critical area that can be really complex when expanding overseas. VAT rules can vary significantly between countries, and determining the correct VAT treatment for goods and services supplied cross-border can be tricky and require a thorough understanding of local VAT laws. So again, taking specialist VAT advice is going to be really critical to make sure that everything's compliant.
Yeah, I think we could spend a whole webinar on on VAT. So not going to delve into detail of that, but obviously get in touch with your sort of regular partner or one of us on the panel if you've got any particular questions around VAT. So, I mean, Ruth, what about, you know, if we're sending people to an overseas location, does that sort of create a permanent establishment issue, or does using an employer of record sort of get us around those problems?
Yeah, so I explained before what generally constitutes a PE. So having a fixed place of business, aka a fixed place of business PE, or having employees, agents overseas concluding and negotiating contracts. That tends to be referred to as a dependent agent PE. So those would generally create a taxable PE. But so sending employees abroad, sending employees overseas, it doesn't automatically in itself result in a PE. It comes down to the nature of what they're doing, the nature of their activities, rather than the mechanism through which they're employed. So that could be by direct employment, or as you said, through a employer of record, an EOR, if that was the route chosen. So using an EOR doesn't in itself get round to having to consider PE issues. You need to think about the first principles of what the employees are doing, and not all activities will create a PE. Particularly if they're of maybe a preparatory or auxiliary nature. So activities like sales and marketing might fall within that category. The scenario could be that individuals are engaged by the UK company to go overseas and investigate the market, generate leads, which are then passed back to the UK company to develop and convert. It's not until people start habitually negotiating and concluding contracts overseas that we get into PE territory. So yeah, it's essential to understand the specific PE rules in the countries where you're considering expansion. Each jurisdiction has got its own criteria and interpretations regarding what constitutes a PE. And the PE clauses of double tax treaties can also be used if that would improve the position. And again, getting to the bottom of these issues, it requires collaboration. And again, we do regularly collaborate with our more global colleagues to navigate all these complex rules.
Thanks, Ruth. So, John, just coming back to you again. So once a business is more established overseas, what do we need to consider from a sort of a global mobility perspective, particularly as more sort of staff maybe moving across the border?
Okay. Yeah, so it sounds like the scenario here is perhaps an overseas subsidiary has been set up. If that overseas subsidiary is to hire staff locally, then they're going to have to deal with any payroll registrations in that location, and deducting appropriate tax and social security, issuing employment contracts, any statutory benefits in kind. Now, as you say, there's with a separate subsidiary set up overseas with staff hired, there's likely to be a lot of cross-border movement between the UK and overseas. So, for example, UK staff might be posted out to that overseas subsidiary, and we need to consider the tax and payroll implications of that, which will vary depending on whether it's short or longer term, which I sort of broadly covered earlier on. But we might also have employees from the overseas location visiting the UK, possibly even for very short business trips, so a few days, maybe up to a month. And although there might be some treaty relief available for those short trips, if they're from a country that has a double taxation agreement with the UK, such that their salary is not subject to UK tax by virtue of visiting the UK, there is a need for the UK company to once a year report to HMRC on who has visited the UK and for how long, to effectively substantiate the fact that treaty relief would apply for those employees and therefore no income tax should have been withheld on their salary whilst in the UK. Now, we might also have longer term assignees being posted from the overseas sub back to the UK, and they will need to be added to the UK payroll and subject to UK taxes. If there's a reciprocal agreement for social security, it may be the case that they don't have to pay into UK NIC, both employee and employers NIC, whilst they're in the UK. And one final point to mention here is that there's a common misconception that if we had an individual from overseas who was actually a statutory director of the UK company, who visited the UK company to attend board meetings, even if the board meetings were maybe 1 or 2 days a year, unfortunately, double tax treaties don't typically provide any protection for directors from income tax. So overseas directors should be added to the UK payroll with any UK income tax deducted related to a portion of their earnings for their time spent in the UK. So that is something that's often overlooked when we get to these cross-border situations. Now, the overseas subsidiary might want to consider alternative hiring options overseas. For example, perhaps they might need employees, but they might also want to engage with independent contractors, particularly where there's some short-term projects that might need to be fulfilled. And what you need to look out for, as you do in the UK, is whether the overseas country has any anti-avoidance rules where the overseas company needs to consider whether or not those contractors work like employees or not. So, for example, whether the overseas company controls those workers in terms of how they work and where they work, and whether the contractors work for anybody else or whether they're wholly full-time working for the overseas sub. Where they're concluded to be like an employee, they need to be taxed like an employee and added to the payroll. So it's really important that you do consider the use of contractors in a lot more detail under local rules in that overseas location. The other alternative is what's known as a professional employer organisation, which is very similar to the employer of record model that I described earlier. It's a co-employer of the staff overseas, so they'll deal with including them on a payroll and paying over local taxes and other HR related matters, so effectively outsourcing the admin process so that the overseas subsidiary doesn't have to deal with it. Again, like my final point here is that if a PEO is used, due diligence is key to make sure they are doing what they're doing. If they're not, then the liabilities might be able to pass back onto that overseas subsidiary or possibly even the UK company.
Thanks, John. So somebody's asked, that they're at the very early stages of considering overseas expansion, and they kind of want to know which of these points kick in if all they're doing at the minute is just undertaking market research with the UK employee in that country.
Yeah, so it depends on how long they've been out in that country for. If it's only been for a few months, for example, and there's an intention for them to return to the UK perhaps before the 6-month point, then providing there's a double tax treaty with that other country, the chances are there won't be any overseas taxes due on that employee's salary. And so there's no need to consider any payroll requirements or the employee potentially having to pay over any income tax charges in that location. But if the periods are going to be longer than 6 months, there is a need to seek advice in that overseas location now because the chances are there was a liability due from day one of working there.
I think from a direct tax perspective as well, I was talking about PEs. I think in that scenario, if an employee is over there just doing market research, I think the working assumption would be that that's not sufficient to generate a PE, a taxable presence, because those activities would probably be sort of preparatory or auxiliary and therefore wouldn't fall within a dependent agent PE. So I think that would be the hope there. But again, it's just, you know, you need to kind of look at exactly how long they were there for and what they were doing.
And Ruth, what about funding? You know, we're going to fund these overseas activities somehow. What options do we have in that regard, and what are the various tax implications of each of the options?
Yeah, so the options to finance an overseas sub, it will generally involve a decision between whether to use debt or equity finance. With debt funding, a UK lending company can then extract funds back to the UK through loan repayments and interest payments. And typically the interest paid by the overseas entity, you'd expect that to be tax deductible for the payer, subject to certain other rules, and taxable for the UK recipient. However, it's crucial to be aware of withholding tax on cross-border interest payments. That's when entities are obliged to deduct tax from payments of interest overseas. So, for example, with a £100 interest payment, a country with a 10% interest withholding tax requirement would pay 90 to the lender, the UK lender in this instance, and then 10 to its tax authorities. There are ways to mitigate this, such as utilising treaty relief provisions. So you look at the tax treaty between the UK and the overseas country and see whether the interest clause provides for a reduced or hopefully nil rate of interest withholding tax. And since Brexit, UK businesses must rely on the UK's tax treaties with EU countries to address these withholding tax issues, as it can't benefit anymore from those EU directives that are in place that allow for the payment of interest and dividends and royalties cross EU border without withholding tax. On the other hand, equity funding is generally harder to repay compared to debt, and so it provides a more permanent capital. While it avoids the need for regular interest payments, similar withholding tax considerations apply if dividends are paid back to the UK, as most countries do impose a dividend withholding tax. The UK doesn't. It's worth noting that UK companies aren't subject to tax on dividend income received, subject to a very few exceptions. So the extent that treaty relief can't get the dividend withholding tax reduced to nil, then any withholding tax deducted would become an actual tax cost, as there wouldn't be any UK tax payable against which to offset the foreign withholding tax. And finally, it's worth also considering some less obvious funding options, perhaps, such as the availability of innovation tax incentives like R&D tax credits, also grant funding. Those could be of particular relevance to businesses which involve a high degree of scientific or technological innovation. And again, we've got specialist teams both in the UK and in Europe who can advise clients on those options.
And what about, I mean, sort of, you know, once you've been overseas for a lot longer, the expectation is there might be some sort of transactions flowing in both directions from UK to overseas and vice versa. What are the sort of the tax considerations that we need to think about here?
Yeah, so once things get going, there will be cross-border transactions between the UK parent and the overseas entities. You might see recharges for services provided by one entity to another being made, or possibly not being made when they should be, or staff employed by one entity being used to service contracts entered into by another entity. And that's where transfer pricing principles come into play. Which is, so transfer pricing is an internationally recognised fundamental principle that requires group entities, related party entities, to transact with each other on an arm's length basis. So they need to price intercompany transactions as though they were independent parties acting at arm's length. So that's designed to counter profit shifting and ensure that each entity within the group is appropriately taxed on the profits it generates. So you can see how easy it could otherwise be to artificially shift profits from a high tax jurisdiction to a low tax jurisdiction by manipulating intercompany pricing. So when a group gets to the position where it needs to consider transfer pricing, there are internationally recognised transfer pricing methodologies that can be used. And it will be necessary generally to put together suitable transfer pricing documentation that describes and documents the intercompany transactions in scope, and evidences the arm's length nature of intercompany pricing, with reference generally to third-party benchmarking. And transfer pricing advisors such as ourselves, we would have reference to special software to derive third-party comparables for similar transactions that can be used to then set intercompany pricing that's then demonstrably and defensively arm's length. And different jurisdictions will have different transfer pricing documentation standards, although there is a generally accepted international standard form of documentation that's based on OECD guidelines. But really, if transfer pricing weren't mandatory, there's still a solid commercial rationale for applying arm's length pricing, because it ensures that profits or losses generated by each group entity are in line with the functions that are being performed by that entity and the risks that it's bearing, and therefore in line with the value that it's contributing to the overall group value chain, supply chain. So there's a fair profit allocation. That could be important for management reporting purposes and monitoring the performance of individual group companies. And just finally, another key consideration for cross-border transactions is, of course, withholding taxes, which I mentioned previously when I was talking about funding options. Apart from interest and dividends, you might also have cross-border payment of royalties, perhaps if there's group intellectual property owned by the UK that's been exploited by an overseas subsidiary. So the same considerations would apply with how to mitigate the deduction of withholding tax from those payments of royalties. So again, you'd be looking at tax treaties and the extent to which they can't reduce the withholding tax to nil, and how to get double tax relief against the UK tax paid on the royalty income. So again, a fair bit to consider, and yeah, as always, lots of international collaboration likely to be required.
Thanks, Ruth. Conscious that we're getting near to the end of our session, but Darren, I just wanted to touch on, if somebody isn't actually looking to set up overseas, but you want to trade with overseas, what other sort of softer alternatives are there if you don't want that big commitment?
Yes. Okay, Esther. So common ways in which UK businesses access overseas marketplaces could be for exporters of goods and services is to use some type of distributor or agent. And in particular, I know that many people that sell into the US and provide goods into the US, it almost feels like using a good US distributor seems to be about the only way to have a sustainable way into the marketplace. So that's one option. Licensing and franchising, so allowing foreign companies to use your intellectual property and brand in exchange for fees or royalties is another one. Entering into a joint venture or a strategic partnership, that can look in so many different ways, but again, I think that's another opportunity. Potentially investing in or buying a foreign company, again, getting a ready-made business is often easier, albeit more expensive. And then also looking at online sales and e-commerce could be another way of accessing overseas markets. Probably the point on all of these, though, is keeping in mind the different legal regimes. I would always recommend UK law, but that's going to come down to negotiating with whoever it is you're collaborating with, and keeping in mind culture and dealing with the rule of law in the Middle East is perhaps a bit different to the UK, which is different to the US. So you need to keep that piece in mind as well. I've got some various horror stories on that, but if you're well advised, then you should be okay.
Thanks, Darren. So yeah, we have come to the end of our session. So thank you, panelists, for all your insight. I think there's a lot of interesting food for thought there. Thanks for attending the webinar. Don't forget it was recorded, so please do share with any colleagues or peers who weren't able to attend today. And obviously, if you are thinking about expanding overseas, whatever stage of the journey you're at, then please do get in touch with us, so we can kind of go through some of these points and give you some more advice. Just another reminder, as I said at the beginning, our next session is the 15th of June, and we're going to be looking at learning and development in the organisation. So please do register for that session as well. So enjoy the rest of your day, and we'll see you in the next webinar. Thank you very much. Bye-bye.